I'm here at the office of Walt Adams, who is the Illinois State Counsel for Fidelity National Title Group, which encompasses Chicago Title Insurance Company, Commonwealth Land Title Insurance Company, and Fidelity National Title Insurance Company. Today's topic will be about insuring access.
Thank you. Underneath the Alta 2006 owner's policy and loan policy, we do insure, underneath the terms of the policy, against loss or damage in the event the property does not have a right of access. For those of you who are not familiar with title insurance, we don't insure that something is. We insure you against loss or damage in the event that it isn't. That's why we're insuring you against loss or damage in the event you do not have access or a right of access. And the right of access language is very important. When we are insuring underneath our Alta policies access rights, we're ensuring you have a legal right, not a physically open way to get there. For example, if your house is on a bluff and you are adjoining a roadway, but that roadway is impossible to get to because you would have to drop 80 feet in the course of about a 10-foot difference over a cliff, that would not be a title claim because you have a legal right of access underneath your title insurance policy. The same would be true if that access was blocked by a waterway without a bridge. All those physical things do not interfere with the legal right of access that is insured underneath the policy. So what do we look for when we insure titles? Well, we look to see if you're adjoining a public road. If you are, then it's a no-brainer. We can insure access to the property underneath the Alta 2006 policies. If you do not have access to a public road, then we would raise an exception. The exception would read something along the lines of, notwithstanding the insuring provisions herein, nothing herein should be construed as ensuring a right of access to the land. We would mirror the language in the insuring provision within the exception. Now, what to do when they don't have access? Well, if your property doesn't have access, perhaps they need an easement for ingress and egress. An easement for ingress and egress is granting the owner of the property a right to cross somebody else's property to get to and from their land. When we're asked to insure an easement for ingress and egress, we have to make sure that that easement was validly created, validly executed by the owner of the property which the easement goes over. In legal terms, we call that the servient estate, and the property that we're insuring is called the dominant estate. When they are correctly and legally created, it's what they call an appurtenant easement, which runs with the land. So, for instance, if I own Blackacre, and I go out and I get an easement for ingress and egress for the benefit of Blackacre, I can convey Blackacre to the next purchaser, and that easement will automatically run with the land for the benefit of Blackacre. It's not personal to me, but it runs with the land. That's what makes it an appurtenant easement, and that's the type of easement that we need to insure. That's not to be confused with a private agreement between two individuals giving them the right to cross property. That's what they call a license. So if somebody would give Walt Adams a license to cross his property, or the right to cross his property, without mentioning that I own property, they own property, that it's appurtenant, that it runs with the land, that is not really an interest in real estate. That's personal to me, and when I sell the property, my purchaser may not obtain those rights. What to do if somebody wants more coverage than what's offered underneath the policy? Because again, underneath the title insurance policy, we're only insuring the legal right of access, not that there's a physically open method to get there. Well, Alta has endorsements. These endorsements, which can be attached to the policy, can give further coverages. Those coverages include that ensuring that there is insuring against loss or damage in the event that there isn't a physically open means of ingress and egress to a public road. That's what we call an access endorsement. Typically, to give those endorsements, we require a survey showing where our property is and where the roadway is, or where the easement to get to the roadway is, and that there be a physically open means of ingress and egress. What do we mean by physically open? Well, we're looking for a curb cut. So if you have a piece of property and they want an access endorsement, you get your survey, and it shows you're adjacent to the road. That's not good enough. That's good enough for the basic policy, but for the endorsement, we want to make sure that it's physically open, that there's a curb cut there. Um, when we're asked to ensure access when there is no easement, or the easement may have been imperfectly created, then we have to do what they call underwriting. Underwriting is a risk assessment. Can we or can we not assume the risk of a defect in the title? Some of the considerations we take into play when determining whether to ensure access when there is an imperfectly created easement may be how long has it been in use? What has it been used for? Obviously, if there's an easement out there that the farmers have used to get to their fields, but now they're wanting to put in a 100-lot subdivision in one of those fields, we're going to be worried about what was the intended use of that easement. Is it being overburdened? That's one of the considerations we take into effect. How many people are using this easement? Often you have an old farm road that has been there, and maybe 5 or 6 different people are using that road as the means of their ingress and egress to their properties. The likelihood of that road being closed is substantially less than if only one person has been using it, or only one person has been using it to get back to hunt on the property, not even living there. So those are some of the risk factors we look at. In addition, if you have an improperly created easement, we may make the decision not to insure the easement, but not to raise the access exception. In other words, we'll still insure your access, but we will not insure the easement on Schedule A of the policy. That gives us the option as title insurers, if there is a claim, to go and find alternative means of ingress or egress to cure the title defect, rather than having to defend the specific easement that we may have insured on Schedule A. Please keep in mind that this is a general discussion of the topic. If you are a consumer, somebody outside the industry, please consult with the attorney of your choice if you have an access problem. If you're within the industry, please consult with the Fidelity National Title Group underwriter to discuss any specific issues. And of course, the opinions stated herein are my own and not those of the company. Thank you.